This is case number 2007-0271 in the matter of Jennifer G. Lafond and David A. Lafond.
May it please the court, I'm Joshua Gordon. I represent David Lafond. There's more depth to this case than its simple facts suggest. It raises three related issues, which I'll take one at a time. First, there's the bad neighborhood scenario. Second, the authority of the legislature to bundle a group of issues into one to dictate what constitutes adequate notice. And third, what sort of evidence is necessary for a court to formulate a relocation plan outside of the statute. The bad neighborhood scenario is what Mr. Lafond cares about most. What happens if his former wife falls on hard times and moves his children within 20 miles to a bad neighborhood? Normally, the statute would guarantee him 60-day notice, some input, court involvement, a showing of legitimate purpose for the move, that the move is to a reasonable location, and that it's in the best interest of the children. Here, none of that happens. His wife could move to a bad neighborhood. He won't learn of it until after it happens, at which point his children might already be living in substandard conditions and enrolled in a below-average school.
Has she moved at all?
Oh, no.
Why isn't this moot, or non-justiciable, or unripe?
Because the order says that she has the right to do it, and it could happen at any time. And the point is that Mr. Lafond won't know about that move until it after it occurs.
Under the court order,
problem.
if she wants to move more than 20 miles, I thought she had to notify the husband.
If she wants to move less than 20 miles, I think she could just pick up and move.
But more than 20 miles, she needs his consent. She needs a court hearing if he wants one.
If it's more than 20 miles, there's no requirement of court hearing as it would be under the statute, but there's the opportunity to get one. It's the under 20 miles that is the biggest problem here and is where the order deviates from the statute.
I thought the agreement was that either party could request a hearing.
Can request a hearing, but there's no notice. So you can request a hearing, but the move might have already taken place by the time that happens. The second issue I'd like to address is what I call bundled notice. That is what constitutes adequate or overbroad hearing notice, and what role does the legislature have in defining it. Here, Mr. Lafond had no notice that relocation was before the court until moments before trial. My sister argues that he had notice of the entire parenting plan was on the table. Relocation is a necessary part of it, therefore he had notice.
Was there a request for a continuance?
I don't understand the relevance.
My understanding is that you say that you just found out about it at the time of trial. Was there a request for a continuance in order to prepare?
No, there was no request for a continuance, I don't believe, but the ability to get a divorce hearing in the courts is so backed up that I think the prejudice of asking for continuance when you finally have a judge sitting in front of you would be a tough row to hoe. The Morphy and Douglas line of cases demands, as a matter of due process, that parties get notice with specificity of what issues are before the court that day. Until recently, divorce litigants could expect a hearing notice would tell them what was in play. But with the new parenting plan statute, RSA 461A, it requires a holistic parenting plan and specifies the topics that it comprises. By the scheduling order noticing up just parenting plan, as many as a dozen issues could be on the table.
Well, one of which could be relocation, right?
One of which would be relocation.
One of which was relocation, was it not, at the second structuring conference?
No, all the relocation never came up at any of these conferences.
At the second, it didn't come up?
No, it didn't come up. It was what my client regarded as a mutual understanding that the statute would just apply. There was no, the 20-mile, if it came up, if I'm mistaken and it came up, the 20-mile relocation issue didn't come up until moments before trial.
So is it your view that the trial court doesn't have any authority on this subject to deviate from the precise terms of the statute?
No, I don't think so. It can deviate, but that has to, if that's going to be an area that's litigated, I think parties deserve an opportunity to know that that's going to be an area that's litigated so they can call witnesses and so forth.
So if you had had what you thought to be adequate notice, it would be your view that the trial court could have entered this order, as it did?
Well, there is a problem with the what the evidence in the case and what's the amount of evidence it takes to deviate from the order.
But I don't understand your answer to that. Is it your position that the trial court can deviate from the statute or cannot deviate from the statute?
It can deviate. I don't.
And what gives the trial court the authority to deviate from the statute?
Well, the statute says that if relocation is not otherwise dealt with in the order, then the statute is the default setup.
Well, and that was what was true here, because in the temporary parenting plan, the only reference to relocation was the language of the statute, so it was the default.
That's right, and that's what was, any reference to relocation until the moments before trial was just to the statute.
Right, so it seems to me, and perhaps to others, I don't know, that what the trial court did here was impermissible, regardless of how much notice you had, because the parent who isn't the one who's taking the kids someplace else has to have an opportunity to litigate whether that parent can do that before it happens.
I think there's some minimum due process requirements, perhaps with relocation, and I think the statute pretty well encapsulates them. You know, you get your notice, you get your opportunity to comment on it, you get your opportunity to go into it before a judge, and it sets up the burdens of proof and so forth. As long as those issues are adequately dealt with in an order, I don't think it's necessary that the statute by its letter be followed, but I think something very similar to it has to be.
So the wife here was getting a free pass without, the wife in this case would be getting a free pass for within 20 miles without meeting any defined burden of proof.
Correct. She could pick up and move her kids within 20 miles. My client wouldn't necessarily know about it.
How about if she moves them across the street? She got to go through this?
Well, moving across
Sounds
the
like
street,
yes.
I think that's the difficult case. But giving my client notice would not be any harm. I think so. Moving across the street, that's the de minimis move that doesn't make a difference to anybody.
The statute doesn't make that distinction, does it?
The statute doesn't make that distinction,
See,
but nor does this order.
I don't understand your position. Either the statute controls and the judge can't do this, which is what Judge Delanus is suggesting, but I didn't understand you to be arguing that.
Well, the statute doesn't say that. I think the statute says if the order does not otherwise deal with the issue, then the statute, is the default.
So what are the limits?
Process.
So what are the limits? If you take it out of the statute, are there any limits?
Well,
Trial judge can do anything, can he? Or she?
there's a problem with the evidence necessary to set up to have a move with nothing else. If the statute requires that a showing of legitimate reason.
But the statute doesn't apply, right? If the order is addressed or the parties have agreed, the statute's out the window.
Yes, but what are the considerations that a judge must take into account in order to structure a move regardless of the statute? And I think those
Presumably
issues.
that's the best interest of the child, wouldn't it
Best
be?
interest of the child would be the overriding concern.
But the court doesn't get to make it up. I mean, the court doesn't get to say, well, thank you for sharing your parenting plan. I think I'll adopt that. I mean, there has to be some notice, some hearing, some opportunity to contest the issues which the statute would automatically govern by default, right?
Correct.
And that didn't happen here.
That didn't happen here, and it wouldn't happen if there were a move less than 20 miles. There would never be any consideration of what is in the best interest of the
But
children.
your position seems to be that the trial judge can do something inconsistent with the statute as long as it's in the order, right?
Yes.
So the trial judge could say you can move anytime, anywhere, without notice or anything like that.
I think there's the problems with the override, if that
Either the
occurred.
trial judge is bound by the statute or not.
Well, the statute gives the trial judge some out. The statute says if the order does not otherwise deal with the matter, I'm not quoting verbatim, then the statute controls the process. So I think the if clause gives the judge some opportunity to structure a relocation scenario or relocation process that is not, lockstep the letter of the statute. Nonetheless, the considerations that the statute sets forth, that it's a legitimate purpose, the move is for a legitimate purpose, that it's a reasonable location, and what are the overriding best interests of the children, those are the sorts of issues that the judge would take into account, certainly the best interests.
Isn't the existing parenting plan in this case the temporary parenting plan?
No, I think there's a permanent parenting plan incorporating the 20-mile move provision.
The statute's a default position.
Yes.
And it can't mean the court deals with it by order under any circumstances, because, as you say here, I agree, you say, the court can deal with it by order, provided there's an established burden of proof. Is that a statutory burden that would apply?
The statute contains its shifting burdens, yes.
But the statute doesn't apply.
Well, it doesn't necessarily have to apply, correct?
But something has to apply.
Something has to apply.
And so what you're saying is if there's a valid court order, in your view, after notice and an appropriate hearing where the appropriate issues are explored, and the court decides you can move 40 miles away if you choose, you might have an appellate issue, but it doesn't violate the statute.
Correct.
What was the temporary parenting plan in this case, if not the existing parenting plan at the moment that it changed?
If I understand your question correctly, there is some confusion in the record of what exactly is the permanent plan, and I think what the court did was take a proposed order and scribble on it.
No, you don't. No, you misapprehend my question, and it may be my problem. The statute applies if the existing parenting plan doesn't deal with relocation. In my view, the existing parenting plan at that moment was the temporary parenting plan. That was the extant parenting plan under which they had been operating for some period of time. It did not expressly deal with relocation.
Or it incorporated the statute, I think.
Just this very language that we're fussing about right now. So if that is the existing parenting plan, then the trial court didn't have the authority to do what it did here.
I'm missing something.
No, I may be missing.
You're not alone.
I think what Judge Lance is asking, if I understood it correctly, is if the existing parenting plan, which, as she's described it, did not contain language on relocation, then the existing parenting plan did not cover that, and therefore it does not govern.
And the statute would govern.
Exactly.
The statute would govern.
I did know what I was talking about.
I apologize.
Maybe Justice Salinas and I should talk privately.
Well, if there's no more questions, thank you very much.
Thank you.
Well, I'm a little troubled by this distance question on a relocation to set this up. The argument that was made in one of the briefs was that this is just an attempt to continually bring back one party into court when there's a move of any type. And particularly disingenuous is where, as I understand it, at the initial hearings, your client wanted the house. So he wants the house, and the question is, obviously, somebody's going to be moving. And his indication was that he wanted the house so that the wife would be moving. Correct?
I think his initial position was he didn't care who got the house. He was concerned that the children stay in the house. I think that was his initial position.
Mr. Gordon, can I ask you a question? If we find that the notice to the husband was adequate, assuming we find that, the hearing, if we find the notice was adequate, your view still remains there was insufficient evidence to satisfy whatever hurdles needed to be satisfied.
Yes.
So even with notice, the wife still loses.
Yes, even given granting the most expansive reading of the evidence, which is on page 9 of my sister's brief, her testimony was that she, Ms. Lafond's testimony was that she didn't want to spend money and time on lawyers, and that she's a good mother. And that was, there was no issues, issues about whether she's going to a good neighborhood or bad neighborhood, or how the conditions of the schools and all the things that you would expect that might come up in a relocation.
You would like us to remand this case to the trial court for hearing on relocation?
I think I would like to remand to the trial court with orders to either adopt the statute or adopt something that gives my client the statutory rights.
Thank you.
you.
Great, thanks very much. Case submitted.